Good morning and welcome to the weekly BICOM podcast Hadiyun. I'm Richard Pater, the director of BICOM's Israel office, and I'm here with my colleague Calev Ben-Dor, the head of research at BICOM. We're also delighted to be joined by Dr Guy Lurie, a researcher at the Israel Democracy Institute, and we find ourselves this morning in Jerusalem in the offices of the Institute. Dr Guy Lurie, thank you very much indeed for joining us. If I could start by asking you, we're here to discuss the legal issues of the Prime Minister following the recent announcement of the Attorney General pending a hearing in the crimes of bribery and fraud and breach of trust. If we could start just from a legal perspective, if you can define those terms just for a layman so we can understand the severity of those charges.
Great, sure, I'll start with that. Bribery is considered the most serious corruption charge a public official may face. It's basically a quid pro quo accusation, whereas the public official has received any kind of benefit from a private individual or a corporation and would have received that in exchange for some sort of benefit that he has the authority to give in terms of his public office. That's the bribery charge. And it should be clarified that it's not just metaphorical money bags that we imagine, but also any kind of benefit that could be passed on to the public official. The second possible charge or indictment faced by the Prime Minister is called fraud and breach of trust, but it's a single accusation with regard to breaching the public's trust, meaning he conducted some sort of public act with not a clear public interest intentions, but in some sort of conflict of interest with those public interests, some sort of private interest that interfered.
And if you could just elaborate, how serious do you think are these charges?
These indictments, and we do not know if they will be accepted in court, but these indictments are considered very serious indeed. Bribery is, as I mentioned, the most serious corruption charge that could be in the criminal book. And breach of trust is also considered very serious. And it has been linked to moral turpitude as the court defined it, meaning it's a very serious corruption charge, meaning that the public official has breached his duties towards the public if proven in court.
You mentioned the moral turpitude. Is that kind of a blanket issue on all cases of this kind, or is it this for the judge to decide when to add the issue of moral turpitude to a crime?
The judge decides this, and when we talk about criminal charges against the Prime Minister, the judge must decide this issue, whether he considers the criminal act in the specific circumstances in which it was committed to involve moral turpitude. That has various legal ramifications in Israel.
Okay, so there's various stages to this whole process. Stage one, we've passed. It was the AG's initial announcement, and the second stage is the hearing. What is the process of this hearing? And I think one of Netanyahu's big claims is when we get to the stage of the hearing, all of the accusations will disappear. It's all based on a house of cards. So A, what is the process? And B, just from your knowledge of, I guess there isn't really a precedent of this, but just from your knowledge of how closely the AG has been working, other hearings of corruption cases of senior officials, what is the likelihood of kind of significant changes from the original announcement to indict to the final announcement?
Great, good question. I think let me say a few words about the process of the hearing itself and what it involves, and then I think that will clarify some things. First of all, a hearing is a process that now any defendant or actually a suspect of a crime serious enough has a right to request and has a right to receive. It involves, generally speaking, not meticulous look into the evidence. It doesn't involve specifics of what are the accusations, but mostly hearings are conducted from a principled legal aspect, legal theoretical debate, and by the attorneys of the suspect, not by the suspect himself. These discussions will go into whether, for example, a criminal charge is actually justified in light of theoretical legal issues, whether, for example, gifts are problematic in the circumstances accused by the prosecution. And we know from previous cases, and we, as you said, we're in uncharted waters in terms of just the first prime minister being considered for indictment, but in previous cases in which public officials were indicted and hearings that they were under, we know that hearings actually do have an influence. We know that several cases there were charges that were dropped, reduced, or even indictments that were completely closed and decided that the proceedings decided not to go forward with that. That said, we know that the Attorney General has been supervising this case in a very close manner. He gave a very thorough and professional decision and followed a very meticulous decision-making process. So we don't assume that there will be major changes in the indictments. That could happen, but the likelihood of a complete closing of all of the cases is rather low. The likelihood is rather low.
You've clearly been following this for a while. Were you surprised by any aspects of the Attorney General's announcement?
I was, actually. There was one aspect that was almost unprecedented, and that's the level of transparency in the Attorney General decision. There were other decisions like that in the past where the Attorney General, especially when he decided to shut cases against public officials, Attorneys General gave very long and specific announcements going into detail about their decision-making process. But the level of transparency here and the different opinions within the Attorney General office and the prosecution in general, that's unprecedented. I think it has very good advantages for the Attorney General, I think, and it shows that he tried to fulfill his duties towards the public and the public's right to know. And I think he also tried to show how very meticulous and professional the process was. And that was important to maintain the public's trust in the Attorney General office, and the public trust depends on the professionalism and the belief that the professionalism of this office is maintained.
So after the hearing, the third stage is an AG decision over indictment. And there are all these kind of political discussions over what Netanyahu might do in that situation, whether he'll try and get the Knesset to pass an immunity law. There are all these discussions about a so-called French law. Just for the non-legal experts, can you explain what are we talking about when we're discussing these options? What does it mean?
Well, generally speaking, the principle in Israel is equal justice for all, meaning that the Prime Minister faces the same process that any other regular Joe would face. But, and that's a big but, the Knesset members, and the Prime Minister is also, of course, a Knesset member, enjoy the possibility of immunity. And so once an indictment is served, the Prime Minister may ask the Knesset to grant him immunity for specific reasons specified in law. That, according to some speculation within the political system, is considered not to be enough. And so and one of the initiatives from the outgoing Knesset was to enact a French law that would grant procedural immunity to any prime minister in future investigations. Now, the proposal that was already proposed in the previous Knesset only looked forward-looking, not retroactively. But there is some speculation that there could be a wider, more retroactive in French law that would grant such procedural immunity. And it's French because a French law because its inspiration for that proposal supposedly comes from the French Constitution, which grants such an immunity to the French president.
But it's different to the immunity law that is currently on the books in the Knesset.
Right. The immunity law that is on the books just allows any member of the Knesset to ask the Knesset to grant him immunity because he believes that, for example, he has been unfairly charged by the prosecution, and for other specific reasons. That's a different matter altogether, and he needs a majority, the member of the Knesset, a majority of the Knesset to uphold that immunity.
If that scenario doesn't play out, and after we have the hearing and we have the final decision by the Attorney General, it then goes to court. Again, there's nothing legally or politically stopping the Prime Minister from remaining in his position, presuming he is in that position after the political process. But you still don't think that's tenable. Could you explain that position?
Well, legally, I think you're correct. The law is very specific in stating that the Prime Minister is out of his office automatically only after being convicted, and the conviction is final, meaning it doesn't have any venue for appeal. That said, first of all, just from a practical point of view, it's difficult to see how a Prime Minister will be able to maintain the level of activities of a Prime Minister, and the Prime Minister of Israel is a very busy public official indeed. It's difficult to see how he will be able to maintain that level of activity while also maintaining his defense in court. And we should keep in mind that the defense in court in serious charges is something that is, for anyone, very time-consuming, and also keeps our mind on that. From an ethical point of view, one should also point out that public trust in the government might be potentially hurt by a Prime Minister holding office while facing criminal charges. A public commission that discussed government ethics in Israel about a decade ago recommended that in such cases the minister or the Prime Minister will suspend himself or be removed from office in that stage. So it's difficult to see how the Prime Minister will be able to maintain office from these aspects after being charged. But as you said, the law on the matter is different.
If I can ask a final question, how do you assess kind of the claim that as the announcement has come kind of so close to an election, a general election, and that the public at least has seen now this 50-page document of the Attorney General, and yet if the public still votes, kind of endorses the Prime Minister to continue, and he has the numbers to form the next government, how does that reflect on the legal issues, that the public was aware of this but still supported him?
I think that this would reflect that the decision of the Attorney General to publish his decision well before the elections was the right decision. He gave respect to the public's right to know, and at the same time tried to keep the decision as far away from the elections as possible. Now the public has its mandate and obviously is free to choose based on the knowledge that is given to him, that is publicly available. It was the wrong decision by the Attorney General if he would have kept the knowledge close at hand, concluded the professional decision-making process, and then just sat on it and not published it. And of course, I would hope that ethical issues and corruption are important to the public, but of course the Prime Minister has his right to his days in court and has his presumption of innocence, and of course would assume that the public probably thinks that Prime Minister is still innocent despite the Attorney General's decision. We'll just have to wait and see how that falls out.
Well, exactly. We will certainly be following this with great interest. Thank you very much indeed for your time today.